Okay. For the record, today is August 29th, 2022. This is the preliminary hearing calendar. My name is Brad Gardner. I'm the judge presiding over this hearing today. This is a case of State of Georgia versus Christopher James Robinson. Ms. Robinson is charged in warrant number 2022 WA 12634 with committing the offense of criminal trespass. He's charged in warrant number 2022 WA 12635 with committing the offense of violation of Georgia Controlled Substance Act. He's charged in warrant number 2022 WA 12636 with committing the offense of possession of weapon during the commission of crime. He's charged in warrant number 2022 WA 12637 with use or possession of drug-related objects. He's charged in warrant number 2022 WA 12638 with possession of marijuana less than an ounce. Ms. Robinson is present in court. He's represented by Mr. Rogers, by Attorney Rogers, who's also present in court. The state is represented by Attorney Freeman. Ms. Freeman, would you swear in your witness and present your case?
Thank you, Your Honor. There is also a warrant number that was left off the calendar, 2022 WA 12639. That charge is simple assault.
Okay,
12639.
12639.
Yes, that's simple assault.
Simple assault.
Mhm.
Okay, thank you.
Officer Norris, would you raise your right hand, please? Do you swear and affirm that the testimony about to provide in the matter of State of Georgia versus Christopher Robinson will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
You can lower your hand. Please tell us your name and how you're employed.
I'm Officer Christopher Norris. I'm an officer with the Clayton County Police Department.
How long have you worked with the Clayton County Police Department?
Just over 8 years.
And so were you working with the Clayton County Police Department on August 14th of 2022?
I was.
And on that particular day, did you respond to 776 Lakemont Drive in Clayton County in reference to a suspicious person?
I did.
What did the 911 dispatch advise regarding this suspicious person?
911 caller advised dispatch that a man with a gun showed up to his house talking about killing a DA, and he ended up taking the gun from him. That was basically the information we got before we got on scene.
When you got on scene, Officer Norris, who did you speak to?
When I first got on scene, I observed Christopher Robinson, the defendant, standing next to a Hampton Police Department patrol vehicle with his hands in the air, and the actual off-duty officer at his home standing nearby.
Who did you speak to first?
I spoke to Christopher. Based on the initial information, I went ahead and made contact with him, did a Terry frisk, make sure there was no additional weapons, and then talked to him.
When you did the Terry frisk, did you locate any items on his person?
No additional weapons, no.
What did Mr. Robinson advise?
He had advised me that 3 GBI agents told him to go to the house so he could be transported somewhere to make a statement about a RICO case.
After Mr. Robinson gave you that information, what did you then decide to do?
Well, I ended up talking to before I made any decision on what to do, I ended up speaking with the original complainant, that off-duty Hampton police officer.
Did that off-duty police officer reside in that neighborhood?
Yes, he resided. That was his residence.
And what did that off-duty officer indicate?
That the defendant rang his doorbell. When he answered the door, the Christopher Robinson told him, quote, I'm here to kill the district attorney, Keisha Abrams. Then he saw that he saw that Mr. Robinson had a silver and black firearm in his hand, a handgun. So he stated that he wrapped his arms around Mr. Robinson, causing him to drop the gun. And then
I'm sorry, real quick. Were you able to retrieve that weapon?
I was.
Okay. I'm sorry. What else did the officer indicate?
That once the firearm was dropped, he let go of Mr. Robinson, who ran across the street to another neighbor's house. And at that point, he was able to make the firearm safe and keep it away from Mr. Robinson returning to get it.
The neighbor's house that Christopher Robinson ran to, did you speak to that individual?
I did.
What did he indicate that happened?
All he really stated was that he went outside and saw Mr. Robinson sitting on a chair in his garage, talking about and looking for the mayor of Clayton County, given the same name of Keisha Abrams, and then advised that he was Arthur's grandson and pointed down the street to a direction which we later learned is his house.
When you say you later learned it was his house, that's the defendant's house?
Mr. Robinson's house. He pointed down Edgewater Drive toward where we later learned he lived.
When you arrived on the scene, Officer Norris, just so we're clear, was Mr. Robinson still there on the scene?
He had returned back prior to my arrival, yes.
Were you able to determine why he had returned back to that location?
I'm not sure.
When he returned back, did he return back to that off-duty officer's home?
Yes, to where he was standing next to the patrol vehicle when I arrived. Is apparently where he went back to.
Was he doing anything while he was standing there?
At the time, just standing with his hands up.
At some point in time, did you decide to place Mr. Robinson under arrest?
Yes, there was a large amount of items on the off-duty officer's front porch. A cooler, a pair of camo coveralls, had the odor of marijuana emanating from it. I initially asked him if, for consent to search the items, which he said he acquired over the last 5 years. But then supervisor arrived on scene and basically advised it best to go ahead and make the arrest for the original incident of showing up to the officer's house with the gun and everything. So then we ended up searching all the rest of the items afterwards.
If you could, Officer Norris, tell us specifically what you located in that stack of items.
Okay. Plainly visible, there was a large rubber, like blue bong. Had a little bit of a burned green leafy material in the bowl. There was a small packet. It was decorated. It said Greasy Candyland, and it said cannabis flower, net weight 3.5 grams. And it also had the California Universal Cannabis symbol, which is a triangle with a marijuana leaf, exclamation mark, and CA. Inside of that bag, there were several large pieces of a green leafy material. In one of the bags, there was we found 4 digital scales. We found a very large stack of what we found out to be motion picture money. I believe they were all 20s. There was a large pint-sized bottle of promethazine hydrochloride. Had a small amount of liquid in the bottom of it. There in the cooler that was there were several bongs, tobacco grinders, pipes, replacement bowls for bongs. There was even a yellow gas mask in there.
And Officer Norris, how were you able to determine who these items belong to?
I asked him, and he said that he had been acquiring the items over the last 5 years. Mr. Robinson did.
Officer Norris, in your years working with the Clayton County Police Department, based on your training and experience, the bonds that you indicated that you found, what are the bonds used for?
They're used for basically smoking. I mean, it doesn't have to be marijuana, but they're basically just used for smoking.
You indicated that one of the bongs at least had some type of burn material, I believe you stated. Were you able to determine what that material was?
What wasn't burned was green and leafy. Based on my knowledge, my training, knowledge, experience, I recognized to be possible marijuana, and it was all entered into evidence for further testing.
Officer Norris, you indicated also that there were some, I think you said scales or grinders in that stack also. Based on your training and experience, what are those things? What is the purpose of those items?
Alone, not much, but when you get them together, they could be typically used for marijuana, either production, packaging, sales.
Okay. You testified that you found some promethazine. Was that field tested?
It wasn't field tested, but it was there was a Department of Forensic Sciences form filled out, and it was sent off to GBI for further testing.
Officer Norris, at the time when you sent that off for testing, why did you believe that was promethazine?
It was labeled as promethazine hydrochloride. It was a 1 pint bottle, and it said promethazine hydrochloride on the bottle.
Did all of this happen in Clayton County?
It did.
Thank you. That's all I have.
Ms. Rogers?
Thank you, sir. Let's see. Officer Norris. First question, as far as the incidents that are alleged at the Hampton police officer's house. And well, actually, let me make sure I got that right before I go too deep. So the initial location that we've talked about, that is in the Hampton police officer's house?
Yes, sir. It's the off-duty Hampton police officer's residence.
And let me ask, because you mentioned, I think you said that when you arrived, Mr. Robinson standing by a Hampton County car with his hands up. Is that correct?
Yes, he was standing right next to that officer's patrol vehicle.
Okay. And I just want to be clear. So the patrol vehicle is parked, I guess, on the premises of this residence, like in front or?
In the driveway, yes, sir.
And to your knowledge, do the officer and Mr. Robinson know each other?
He didn't indicate that he knew. They apparently, him and the other neighbor had never seen him before.
But he lives in the neighborhood. That's pretty much how.
We later learned he lived down the street, but they had never seen him before.
And the incident that's alleged as far as what happens when Mr. Robinson arrives at the house, do you know if that's on video or anything, like ring cam or anything?
I don't believe so.
And as you understand it, are the only two people there, the officer and Mr. Robinson, when this exchange happens, the conversation and the interaction, the tussle?
At the front door, yes, sir.
And at no point does Mr. Robinson doesn't ever, like, I guess, show any aggression towards the officer? Is that he just announces why he's there?
He announced why he was there and had the gun in his hand while he did it. So the officer just took the protective measure to.
Yeah, I understand. I just want to make sure that that was the only reason that he did it. I understand, but I just want to make sure.
He made it clear that he never made any overt like threats toward him or anything.
And as far as the statements, I think you said you spoke to Mr. Robinson. The only statements he made were related to, did you say GBI agents had sent him to that location?
Yeah, he said 3 GBI agents told him to go there so he could be transported so he could make a statement about a RICO case.
And when the search that, when you uncovered the promethazine, I know there was some discussion about, well, let me ask two questions. Number one, how many bags or were on the, I guess, the front porch or front stoop or whatever?
There was a cooler, a duffel bag, and I believe just the camo coveralls with the, like I said, that blue bong and that packet of suspected marijuana that were out there. Everything was contained in those.
Okay. And so, and when you were searching through them, initially it was with Mr. Robinson. You had asked Mr. Robinson if he agreed to you looking through them. Is that correct?
Yes.
When do you recall when you found the promethazine, as far as before or after the arrival of the supervisor and the arrest?
It was after.
And had Mr. Robinson been Mirandized and everything when the conversations are happening about the substances or the belongings?
At the time when I first got the consent to search, he hadn't been Mirandized or anything. He hadn't been placed in any kind of custody or detention.
Right. And let me be clear about what I'm asking. What I'm asking is, when you find the promethazine, is that part of that search, or is that the search that occurs after the supervisor has arrived?
That was after.
And not to be a wise guy, but just to be certain, have you ever spoken to GBI about what Mr. Robinson is saying?
I have not.
No further questions at this time.
Any follow-up or redirect, Ms.?
No additional questions, Judge. The state rests.
Okay. Do you have any?
Just the argument. I don't know if am I still here?
Yeah, you're still here.
Okay.
You were breaking up.
Yeah, I wasn't sure.
Mhm.
No, just the argument, Sean. I don't know if you can hear us.
Norris be excused?
Yes, Judge.
Okay, Officer Norris, you can hang around or you can leave. Choice is up to you.
All right. Thank you, Yarny. Have a good day.
You too.
Thank you, Officer Norris.
And so I'm gonna assume you're gonna waive opening, Ms. Freeman?
Yes, Judge.
Okay. Let me hear from you, Mr. Rogers.
Yeah, I'm inclined to submit on most of the allegations. I do take issue with to the extent there's a simple assault allegation. Honestly, I kind of take issue with the criminal trespass also, and the reason I say that is that, to my knowledge, there's no allegation of any damage being done. He didn't actually do anything, I guess, in the sense of like making any threats against the homeowner or anything like that. There's no testimony that he had been told not to come back to the property, or not to come to the property. It seems to be their first interaction. As it relates to the simple assault, I'm not exactly sure what the basis would be, in that the there's no allegation that he, attempted to harm anyone or even really make contact with anyone on the scene or anything like that. The simple assault does require you to try to make some sort of contact. Generally, a person is allowed to carry a firearm in Georgia. So the mere fact of having a conversation or showing up somewhere just in possession of a firearm without, raising it or threatening it to someone, in and of itself, just on those facts, that's not an allegation of any criminal activity.
Isn't simple assault placing a person in reasonable apprehension of a violent injury or receiving injury?
It would be, yes, sir, it would be, but that's what I'm saying is the person that they're talking about that he stated any kind of intent to do anything towards, no allegation that person, number one, that has even exists. Number two, that person was at that location, or that he tried to do anything to the respondent, to the officer who opened the door. The officer simply responded, understandably, based on what he said and the fact that he was standing there armed. So I understand that. I'm not saying the officer shouldn't have touched him. What I'm saying is that he didn't threaten that officer. He didn't try to strike. There's no allegation he tried to strike him, pointed a gun at him, threatened to do anything to him or to anybody like related to the situation. So that's what I'm saying is that there's no, the mere fact that somebody does something that causes alarm or concern does not transform it into an assault. You still have to do something that makes that person think that you have an intent to harm them. That's not what was articulated, expressed, or anything like that. Like I said, I do understand why the officer took steps he took, but it's not a threat against him that was made. It's not a threat against an occupant of the house. The man's clearly, having some sort of mental health issue, but he's not telling you that he's trying to harm you. And that's why I say I would ask for a dismissal, because there's no actual attempt to cause an injury to anyone or to commit any act. Unless, like I said, unless we're willing to say that merely going to someone's house while armed, even though it's awful to be armed in and of itself, and saying something, alarming, is an assault. And that's not, I haven't seen any case law that says merely those two things to some sort of an assault. It's a cause for concern, it's a cause for detention, all these things. But to call it an assault, I think is a step too far. So
okay, let's flip that around, Mr. Rogers. I show up at your door, you don't know me. I have a gun in my hand, and I tell you I'm looking to kill DA Keisha Abrams.
Right.
And you shoot and kill me. Do you think that you would be within your right to do that?
Well, I not to my knowledge, no, because there's not been any allegation that this person was attempting to commit a forcible felony at that moment or tried to force entry into the location. They're not saying he tried to force his way into the habitation or anything like that. So it wouldn't be a defensive habitation because he's not making that argument. See, like he rang the doorbell and had a conversation with the person that opened. He didn't try to rush it or anything like that. And again, like I said, I don't think that, while I understand the impulse, and if you ask me this when I was not a lawyer, if you caught me out in the streets and you asked me what I would probably do, that's two different things. I might have to take it to a jury, and that's all well and good, but I don't think that the mere fact of someone, because if they're armed and I have not, now we had previous dealings or something like that, prior difficulties, things of that nature, something to inform it. Or if this person tries to force their way in, or if they try to raise this gun to me, then I think so. But I don't think that the mere appearance of a person who is armed on my front door gives me the right to shoot them.
And I could be wrong, but if he showed up at my door under these circumstances, it'd probably be a phone call made to the coroner. And I'm just saying, and I don't think I'm outside of my rights. But go ahead, Ms. Freeman.
Well, Judge, for everything that you just stated, I am asking that both charges be bound over. I mean, here we have this this individual who shows up unwanted to this person's home, and rings the doorbell, and the first thing out of his mouth is, "I'm here to kill a DA." And he has a loaded firearm in his hand. So I certainly think that is enough for, at least at this level, to put a reasonable person in a reasonable apprehension of fear. And so we are asking that all of these charges are bound over to Superior Court.
Okay, I am going to agree with Ms. Freeman. I'm gonna bind this over all counts to the Superior Court of Clayton County. But I do want to take 5 minutes to speak to Ms. Freeman and Mr. Rogers in breakout room. We're gonna go to breakout room 1.
Okay, and Judge, and I will say that we do have one last hearing. That's with Officer Gums, who's on.
And the state's ready on that one.
Okay, let's do that now.
Okay.
And then we'll hold the conversation, because I do have concerns that I want to address to both parties. And so this is Mr. I'm sorry.
I'm sorry, sir. This is Miss Mosley. I'm still here. I was just I've been listening and doing some other work, but whenever y'all break away on the gentleman that just came, if I could be allowed to come in, because
yes, ma'am.
That Sunday.
Yes, ma'am. And that Ms. Pitts, if you want to be involved in that conversation also.
Thank you, Judge.
Because I think I did the warrants on that, or I did first appearance on that case, and I do have concerns. So let's bring up Mr. Kraft. Okay, we're still live on YouTube. Once I see Mr. Kraft, I'll begin my speech. Okay, for the record, this is August 29th, 2022. This is the preliminary hearing calendar. My name is Brad Gardner. I'm the presiding judge, presiding over these hearings today. This is case of position 15 on my calendar, State of Georgia versus Reginald William Kraft. Mr. Kraft is charged in warrant number 2022 CW 50420 with committing the offense of criminal trespass, and he is also charged in warrant number 2022 CW 50421 with committing the offense of criminal damage to property in the second degree. Mr. Kraft is here. He's represented by the state. He's represented by Attorney Hill. The state is represented by Attorney Pitts. They're both present. Attorney Pitts, would you please swear in your witness and present your case?
Yes, Your Honor. Officer Gums, if you would raise your right hand. Do you solemnly swear and affirm that the testimony that you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, if you could put your hand down, state your name and your agency.
Officer Trina Gums, and I work for Clayton County Police Department.
Okay. And Officer Gums, how long have you been with Clayton County Police Department?
3 years.
And what is your current rank at the Clayton County Police Department?
Patrol officer.
And as a patrol officer, what are your duties?
Answer calls.
Okay. Bring your attention specifically to January 27th of 2022. Were you working in your official capacity?
Yes.
Did you have an occasion to respond to 802 Rosewood Circle in Jonesboro?
Yes.
And is that located within Clayton County?
Yes.
What was the purpose of responding to that incident location?
The tenants of that home called 911 basically to have an officer present based on one of their roommates. They've been having some issues with his behavior where it had made it unsafe for them to be at the home. When they arrived at the home to gather some items, they saw that some of their personal items were damaged.
Okay. And so are we talking about Mr. Gomez?
Yes, this is one of them.
Oh, Sarita, I'm sorry, Miss Gomez, Sarita Gomez? Is that one of the people that lived at that location? Or was it Victor Gomez?
Victor Gomez.
Okay, thank you. And the other individual that lived at that home that reported property damage, was that Zelina Limon, Limon?
Yes.
Okay. And to your understanding, did both Mr. Gomez and Miss Limon live in this residence with Mr. Kraft at some point?
Yes.
Okay. And at the time that they called to get an escort, what was the situation?
They advise for the past week, his behavior has just been erratic, just over the place. They're not sure, where his mindset was. They advised at one time that the suspect's mom had called to do a welfare check on her son, I guess just based on issues that he has been having.
And that was Mr. Kraft? Her son was Mr. Kraft?
Yes.
Okay. And in the past week, had Mr. Gomez witnessed the defendant with any weapons?
Yes, he has. He stated that he did.
Okay. Do you know what weapon he said he saw him with?
He's not sure, like the make and model or the size, but he did mention that he did have a weapon in the house.
Okay. And when we say weapon, are we saying gun?
Gun, yes.
Okay. And so tell the court what property was damaged.
So the one damage I was seeing was to Mr. Gomez's vehicle. He had a bullet hole through his hood, which went into possibly the engine compartment as well. A hole was seen. Once we lift up the hood, we did find a shell casing on the floor. The garage door was damaged as well, and that would be the homeowner. That's Miss Salida Gomez. The garage door, I think it was the right side. It came off of the hinge. Both of the tenants advised the last time they were at the home, they know that the garage was working fine and didn't have any issues. Another incident which would be, I think the female hard door to her room was broken into. The suspect did text her saying that if she doesn't come home within a certain amount of minutes, that he was going to break down the door.
Okay. And based on your report, did Miss Zelina report that the defendant texted her and said that she had 26 minutes to get home because he needed something out of her room?
Yes.
Okay. And thereafter, did he text her, now your door is open, with a picture of the damage done to the door?
Yes.
Yes, Your Honor. This is leading.
I'm gonna allow it. Go ahead.
Okay. Based on your investigation, what did Zelina, Miss Gomez, and Mr. Gomez, who did they say had exclusive access to this home?
That would be the suspect.
Okay. Yeah, I have no further questions, Your Honor.
Okay, let me ask this question because I'm not clear. Is this a rooming house situation or a landlord-tenant situation?
It was more of a landlord tenant situation. So the Mr. Gomez, that home belongs to his mom, and they advised they were renting the rooms.
When you say rooms, I'm saying, is it the whole house or is it just like a room?
It's a house, and I guess with each bedroom belong to the three individuals.
Okay, so I would consider that a rooming house situation. So that's where I'm trying to get
Okay.
a better understanding of it. Go ahead, Ms. Hill.
Thank you, Your Honor. So yeah, that is a good question. So Mr. Kraft did live at the residence, is that correct?
Yeah.
And did he have a lease? Was he a tenant?
I'm not sure as far as what leasing agreement they had. They just advised that he lived in that room, and past history showed that calls were made out to that home pertaining to him.
How many tenants lived in the home? Do you know?
Just those three, the suspect and then the two victims.
Okay. So let's see, Officer Guns. So did either of them witness the incident?
No, based on how the suspect was behaving, they did not feel safe staying in the home. So they would just come to the home when they needed to gather items, as the initial reason why they called us, just to be on the safe side, that they don't have any interactions with Mr. Kraft if he was home. So they just came to gather some items, and once everything was finished, they left.
Okay. Was there any video footage of the damage occurring?
No.
Okay. You stated that the garage was broken, the garage door to the home,
Yes.
as if someone tried to gain access into the house?
It could seem that way, because I'm sure unless they, I'm not clear if each individual had like a garage opener, but they said if there's any way to access the garage, is the little keypad that's inside the house.
Okay, but Mr. Kraft did have access to the house, meaning that he was a tenant, right?
Yes.
Okay. Were you able to speak with Mr. Kraft about the incident?
No, the female, the female, she tried to call back that number where the text was given, and it went straight to voicemail.
Okay. You said that she received text messages from Mr. Kraft.
Yes.
What was the content of those text messages?
The message just stated that he's given her a certain amount of time to come home, or else he's going to kick in her door. And then when he was able to gain access to her room, he sent her a text saying that, I think your door is now open, and just a picture of the door being damaged.
Where were those text messages sent?
According to my report, he told her if she's not home by 10. So
No,
maybe
what date?
I have message January 26th.
What date did they call you?
The victims?
Yes.
On the 27th.
Okay.
Of January?
Of January, yes.
Thank you.
Do you recall what time?
I have here 1940.
So around 7:40 p.m.
Mm-hmm.
But she received the text messages on the day before.
Yes.
Did you ask them why didn't they call the police before?
They were not home.
So they did not come home anytime I guess, after those text messages until they returned and called you guys. Is that correct?
Correct.
Okay. So you said that Mr. Kraft was not on the scene. Did you do a search of the home?
Yes, I did make entry into the home. They showed me where his room was. They showed me where each of their room was located.
Did you go into his room?
No,
Okay. Let's see. You said that there was a bullet hole in the car. Is that correct? In the truck?
yes.
Were you able to determine what type of gun that the projectile was from?
It was a 40 caliber. That's the only thing I can tell you.
Okay. Okay. Did you find a 40 caliber gun in the house anywhere?
No.
Okay. Okay, so just to be clear, I believe you said that Miss Selena's parents owned the home. Is that correct?
It would be Mr. Gomez. I think it's his mom.
Mr. Gomez's mom.
Mom or grandmother, not too sure.
Okay. So you decided to take out the warrants based on the testimony from the two witnesses? Is that
Yes,
correct?
ma'am.
Even though they didn't actually see what happened?
Yes, ma'am.
How long had the dispute been going on between these parties? Do you know?
No, I can't give you a time frame.
Was there, you said there was a history of calls to the police prior to this incident?
Yes.
Who were the primary callers? Was it Selena and Gomez?
I know one of the call that they mentioned was the mom calling to that location to do a welfare check. Pertaining to them making calls before, I honestly can't remember at this time, but it did have a history where his name would be in the call log.
Okay. All right, and let's see. I think that is all of my questions. Thank you.
Ms. Pitts, is there any redirect?
No, Your Honor, I don't have any redirect.
Do you have any other witnesses?
No, Your Honor.
May Officer Gums be excused?
Yes, Your Honor.
Officer Gums, thank you for being here and waiting till the end of the day. God will bless you one day for this service. But you are free to go, ma'am.
All right, thank you.
Ms. Hill, do you have any witnesses?
No, Your Honor.
Is there any argument?
Yes, Your Honor.
Okay. Are you going to waive opening, Ms. Pitts?
Yes, Your Honor.
Okay. Ms. Hill, I'll hear from you.
Your Honor, I have to ask against Mr. Kraft. The testifying witnesses, I guess, that called the police, Ms. Elena and Mr. Gomez, they did not have personal knowledge that Mr. Kraft did this, that he was actually there whenever it was done. And they also claimed that he had exclusive access to the house, which has been shown not to be true because, I mean, the actual owners probably had access to the house as well as the garage being broken into. I mean, it looks like the garage was broken into. She said there was damage to the garage. It was consistent with being broken into. It looks like someone else could have broken into the home. But Mr. Kraft would not have needed to break into the home. There would be no reason to destroy a garage unless it looks like somebody was trying to break into the home. But he had access to the home. They said that there was a bullet hole in the car, but no one saw Mr. Kraft shoot a bullet hole, and it is the state's burden to show that there is at least some evidence that he did it. They can't state what type of gun that they ever saw him with. No one can put him there to say that he shot the gun off. I mean, if there was someone shot a gun, it seems like someone would have called the police to say we heard a gunshot or something to that extent. I mean, there was nothing. We don't know when this happened. We don't know how it happened because there was no one there to say, oh, he did this. I mean, anyone could have did it. Someone could have broken in and did all of this. I just don't know. At best, they may have something with the door, the damage to the door. But again, Your Honor, the state has not even alleged an amount in damages today. There was no testimony as to how much there was in damage to any of the property. So at the very least, we do ask that you dismiss the criminal damage to property. And should Your Honor choose to bind over something, we only ask that you bind over the criminal trespass of property. Thank you.
Ms. Pitts?
Your Honor, as far as preliminary hearing is concerned, I believe the state has made out probable cause. I believe the testimony before the court is that the defendant had been acting erratic in the last week. I believe that the officer testified that none of this damage had happened past the week, that all the parties lived there up until a week previous. I believe the testimony before the court is that Mr. Gomez saw the defendant with a firearm, and counsel says that somebody would have called if the gun had been shot. Well, I think the evidence is uncontradicted that the gun had been shot. We are clear that the car had a bullet hole in it and there was a casing, so there was a gunshot. I don't believe there's any evidence of contradiction there. And then the owner of the vehicle, as well as the grandson of the homeowner, stated that he saw the defendant with a gun. Additionally, there is direct evidence from Ms. Zelina stating that the defendant told her she had 26 minutes to get home before he kicked in her door, and then sent her pictures thereafter of the door kicked in. Additionally, Your Honor, I think what the testimony counsel elicited was the garage was damaged as if somebody might have been trying to break in. She said, yeah, you could say that. The garage was damaged. And I think the evidence is that the only 3 people that had access to that house was Mr. Gomez, Ms. Zelina, and the defendant, Mr. Kraft. I don't believe there's any evidence before this court that the grandmother committed this damage to her own property for the court to consider that some other guy did it. Your Honor, based on the testimony, I believe that the court has enough evidence to bind this over for probable cause for the damages that were testified to by Officer Gomes.
I agree. The state has a theory, and the theory is from the witnesses that whatever they're experiencing with Mr. Kraft, they believe that he did this. Now, the state's going to have to prove it at trial, but for probable cause, it's 51%. It's that the person may have committed the crime, and under the testimony that was elicited, he may have committed the crime. They don't have to prove it right now, but they have a theory. So I'm going to bind these charges over to the Superior Court of Clayton County. Both charges on the criminal damage to property in 2nd degree and the criminal trespass. And I believe